Thank you, Mr Speaker. I rise on behalf of the Greens to speak on the Civil Liability Amendment Organisational Child Abuse Liability Bill 2018. This bill seeks to make it easier for victims of child sexual abuse in institutions to prove that the organisations under whose auspices they were abused were legally liable for that abuse. It does so by creating a duty on organisations to prevent child abuse and to create a legal presumption that that organisation or an organisation has breached the duty if a child for which it has responsibility is subjected to child abuse by an individual associated with the organisation. There is a reverse onus of proof on this offence, meaning the institution itself has the burden of proving it took all reasonable steps to protect children in its care. Such organisations are taken to include incorporated and non-incorporated associations, as well as public sector organisations, though not the state itself. Successors to an organisation are considered part of the same organisation, and this makes tracing liability much simpler, particularly if an organisation undergoes a number of reinventions over the years. The bill will also make the organisations vicariously liable for child abuse committed by employees and persons akin to the employees, and this would include, for instance, members of clergy. A further change is made that allows victims to bring civil proceedings against unincorporated organisations that may be liable for the abuse. The Greens absolutely support this bill, and in doing so make our commitment to continue to work to ensure that the barriers to justice for victims of child sexual abuse are removed from the law of New South Wales. It is clear that the power imbalance and the vulnerability of young people connected with these organisations and institutions is not one that is set in the favour of those young people that face and risk child abuse, and it is clear that the law needs to step in to provide protection and support and assistance to them and the victims of child sexual abuse of the past as well. I acknowledge Greens Upper House MLC David Shoebridge is particularly committed to this work and has been working tirelessly with communities, with people and with survivors around this issue since he first entered Parliament. In fact, David told me that one of the first issues that was raised with him as the Justice spokesperson for the Greens when he was elected was about the access to civil claims for victims of child sexual abuse, and particularly what is known as the Ellis defence. It is very significant then, not just to David, but to survivors and those impacted by this injustice and their families and loved ones and those that have seen them suffer, that this bill finally overturns this defence. It is a testament to the work of John Ellis and many of the survivors and their advocates that we are in this place finally removing this obstacle to justice. The Ellis defence is the apparently paradoxical position faced by victims of child sexual abuse when they attempt to seek compensation from the Catholic Church. Even if they are successful in the court, they may find that there is no institution called the Catholic Church at law which holds assets that would enable it to pay compensation. This is in part due to the legal structures of the Church, where the Catholic Church Property Trust holds its assets, and where church lawyers argue that this trust was not responsible for the abuse. Can I just say that it's truly disgusting to even consider or fathom that that would be the argument made, but lo and behold it is, where church lawyers would argue that this trust was not responsible for the abuse and therefore cannot be held liable. It is a nasty legal fiction, and it has been a constant feature of David's work in this place since he was elected in his attempts to have this obstacle to justice removed, and it has been due to the tireless efforts of so many people pushing for this to be changed that we are now seeing this change implemented here in the chamber today. This bill implements the Royal Commission's recommendation to enable survivors to identify a proper defendant to sue, and this in itself is also an important step which practically assists victims to seek compensation through the courts if they so choose, and in doing so rebalances the power between the organisation and the individual that in so many cases has served as an obstacle to justice. We heard in the case of the Ellis defence how this was used as a bargaining tool by church lawyers to reduce compensation offers to victims of abuse, with the rationale that they likely couldn't get any money through a civil suit, so they should settle for less. The changes in this bill operate retrospectively as well as prospectively. It is truly horrifying to imagine a situation where somebody has gone through the trauma of child abuse, to be part of a family or a loved one, to see someone who has gone through that trauma, who has had their faith in organisations and institutions completely removed as a result of the lack of trust that they would now have in those institutions and organisations that wielded completely uncontained power over them when they were vulnerable children, to then see the lawyers, the advocates of the Catholic Church, of the Church, then seeking to further impose injustice onto them, to further impose harm on them, to say that basically they could use this as a bargaining tool to get out of paying what would be just and reasonable compensation for the trauma caused. The government has indicated that this bill is the final part of their implementation of recommendations for reforming civil litigation for victims of child sexual abuse. It is worth noting that the government has committed to provide annual progress reports to Parliament, and there are obviously some areas that the Greens will continue to work closely with the community on in order to pursue justice and all of those recommendations being implemented. Too often in the past we have seen recommendations of Royal Commissions languish, and so it is credit in this case to the important work done by the witnesses, to the brave contributions of so many survivors, that we are seeing changes being made and some of those recommendations being here implemented, and I believe that is truly heartening for those that showed the strength and courage to participate in that Royal Commission, who had things done to them and suffered injustices and abuse that no individual, and particularly no child, should ever have to face. I commend the bill to the House.